join as an observer only.
Are you happy for me to start, or do you want me to wait a couple of minutes?
No, I would be happy for you to start, ma'am.
Okay, perfect, thank you. Well, good morning, everyone. Hopefully you can all hear me and see me fine. If at any point you can't, just put your hand up. We found the best thing is to, if people who aren't speaking can put themselves on mute to avoid any feedback. That tends to work quite well. If there are any problems, I'll let you know. First of all, welcome to this pre-examination meeting in relation to the appeal by Paladin, is that the right way to say it, or is it Paladin? Or Paladin?
It's Paladin, ma'am.
Paladin. Paladin Venture Cauldcoats Farm Limited against the decision by Midlothian Council to refuse an application to modify a planning obligation within a legal agreement associated with Planning Permission 14/00910/PPP. Now, my name is Trudy Craggs. I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, and I've been appointed by the Scottish Ministers to consider the appeal and to determine whether or not to modify the planning obligation. This is a virtual meeting and is being broadcast live, and as such will be stored as part of the DPA website archives and will be capable of repeated viewing. By participating in the virtual meeting today, you're consenting to being filmed. You're also consenting to the use and storage of those images and sound recordings, including any images or information pertaining to you contained in them, for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. Further details of the DPA privacy policy can be found on our website. First of all, thanks to my colleague Callum Henderson for arranging today's meeting, and I think he carried out testing with some of you to make sure you could join the meeting today, so thank him for that too. My colleague Ewan Murray is running the meeting today and hosting it. He's hiding in the background. If there are any technical issues or any sound problems, hopefully he'll jump in and be able to help and resolve them. I'd also ask you that during the meeting, if you can keep your phones and any other devices so that they're not audible. I know you may need to contact people in different rooms or out with your team, that's absolutely fine, but as long as I can't hear your phones or your devices, that would be helpful. So first of all, can we start with a few introductions? Can I ask the lead participant for the appellant to introduce yourself and those who are attending today on your behalf? Oh, you're still on mute. That's the problem with meeting.
Sorry. Well, formally, good morning, ma'am. I'm Fraser Mitchell from Shoesmiths LLP, and I am appearing on behalf of Paladin Ventures, Cauldcoats Farm Limited, the appellant. My witness is attending today and as an observer. That's Jan Kinsman from Education Facilities Management Limited.
Thank you. And can I ask the lead participant for the council to introduce yourself, please?
Good morning, ma'am. My name is Matthew Atkins. I'm the lead officer for planning obligations at Midlothian Council.
Thank you. Nice to see you all here this morning. Moving on to item 2 on the agenda, which is the purpose of the pre-examination meeting, just to set the ground rules. And as I said in the agenda, the purpose of today's meeting is to discuss the procedural arrangements for the examination process, and that was as set out in the agenda, which was circulated last week. There will be no discussion on the merits or otherwise of the case, and I will not hear any evidence this morning. I will be keeping a note for our discussions, and the case officer will circulate to all of you who have attended today a note of the key decisions and the procedural arrangements in the form of our procedural notice. And I will aim to get that out within a week of today's meeting, so by next Monday. This is item 3, the proceedings. The appeal will be progressed in accordance with Town and Country Planning Appeals Scotland Regulations 2013, which can be accessed through the DPA website, but I'm confident you guys are probably very familiar with the regulations anyway. But if you need to find it, it can be done through our website. Moving on to item 4, which is planning for a virtual hearing. Now, as I said, that I think I need additional information to determine the appeal. And I think the most efficient way to do that would be by way of a hearing session. I did think about written submissions, but often in a case like this, you go out with your first set of questions, and sometimes the answers just require more questions, and you get into prolonged written submissions, and actually can be more efficient just have a short hearing, which may not last very long, but just have a good discussion on this issue I think I need to know more about, which is why I've opted for the hearing. It is still anticipated that on the 9th of August, all physical distancing requirements will be lifted. But as you may be aware, this is conditional on those over 40 being fully vaccinated, and there will be a review of the relevant data at that time by the First Minister. She will confirm the lifting of restrictions otherwise 1 week before that. So currently in line with our current guidance, any lifting of physical distancing restrictions will signal a gradual resumption of in-person events, but until then, events will continue to be held virtually, and we as reporters are instructed in the meantime to plan for virtual proceedings rather than in-person proceedings. If restrictions are lifted, the DPA will move gradually back to in-person procedure where that is appropriate. Virtual procedure already planned will be converted to in-person procedure if appropriate to do so, and only where that can be done easily and without any delay to the process. My view is, given the number of parties in this case and the nature of the issues, which are quite discrete, I do feel that perhaps we could continue to do this hearing virtually, even if restrictions are lifted, and I kind of feel that may be more efficient to do it that way. But I'm happy to get views of parties on that, so we can make a decision going forward. So, Mr. Mitchell, can I ask for your views on that?
Yes, ma'am. I agree with you, as does the appellant, that we'd be happy to proceed on the basis of a virtual hearing, really come what may. I think in terms of the First Minister's announcement in August, I think our concern would be potentially having a virtual hearing if the format of the appeal moved to an inquiry session, but it certainly doesn't sound like that's likely. If anything, if it's on the scale, it would tip back towards written submissions rather than tip forwards into an inquiry session. But that would really be the only concern that we would have. So yeah, I would be, well, we the appellant would be very, very content to go forward on the basis of a virtual hearing.
Okay, thank you for that. And Mr. Atkins?
I would agree with that also. The council will be happy with continuing with a virtual session.
Okay, thank you. I think that's really helpful. My view is that it wouldn't tip into an inquiry. I'm very comfortable we should have a hearing session to discuss the issues. So I think on that basis, we will proceed then. It will be a virtual hearing, come what may, on the 9th of August, when the First Minister may make it, or second when she makes an announcement. The virtual hearing would be broadcast live, so to enable interested parties to watch proceedings either live or later if they wanted to. And again, if you needed more testing, we can do that ahead of a virtual session to make sure that everything is in place. And what I tend to do is send out just a few kind of ground rules a couple of weeks before a hearing session, things that I found that in other virtual hearings have made things a bit more smoother. For example, just little ground rules. There's a handful, but it just makes things slightly smoother on the day. Things like having a list of documents before we start the hearing sessions, so people can have documents open, just little things like that, which can make things slightly smoother when we're doing a virtual process. Okay, so moving swiftly on to item 5, which was my provisional assessment of the issues that I felt required further evidence. And I listed that in the agenda that was circulated. And first of all, it was really, do parties generally agree with my assessment of things that required further evidence? And are there any issues that anyone felt I'd missed? So again, if I start with you, Mr. Mitchell.
Thanks, ma'am. Having reviewed the list, the appellant's perfectly content that I think you've covered all the issues that we'd want canvassed as part of a hearing session. So nothing further to add from our perspective.
Thank you, Mr. Atkins.
The council is content with what you've set out there, ma'am.
Okay, thank you. That's again really helpful. If you go with that, it's been a list of items that need a further evidence on. Moving on to item 6, which was the prior disclosure of cases. Now, as you probably are aware from other cases that you've done, there are a number of written exchanges that we require to take place prior to hearing session, and this is to ensure that everyone is fully aware of the other party's case, so there's no surprises when we get to hearing session. Now, the first thing that parties need to do in accordance with appeal regulations is that you'll have 14 days from the date on which the note of the pre-examination meeting is issued to confirm that you both wish to take part in the hearing session, and that is a requirement of the appeal regulations although I am assuming you will both want to take in a hearing session, but it's just a procedural thing that has to be done in accordance with the regs. That will be flagged up in the notice of the meeting, just to make sure no one forgets to do that. I listed in Annex A of the agenda just a provisional timeline. And this was on the assumption that the hearing would take place on the 13th of October. And I think that date is acceptable to both parties, but can I just confirm that, Mr. Mitchell?
Yes, that's correct, yeah.
And Mr. Atkins?
Yes, ma'am.
Okay, perfect. So we will go for that date with the 13th of October. I know there are several issues that I have identified in the agenda that we just agreed and that need discussion. I'm still kind of confident that would only take a day or less to cover those, primarily because I think some of the matters might actually not require much discussion once I get the hearing statements and rebuttals, which will narrow down the issues. And two, there might be a bit of overlap between some of the issues I've identified anyway, which might mean the discussion gets less and less as we go through the agenda. So I'm fairly confident I think we could do it in a day. Are the parties content that we just set one day aside for it, Mr. Mitchell?
Yes, ma'am. I think in our estimation, a day would be about right. I think the only question I had in connection with that was just, I know from previous hearing sessions, there's been a restriction imposed in terms of the duration over which evidence will be heard really at any one sitting. So it was just really whether there'd been any alteration to that, or whether, you know, I suppose you're content that the evidence can be taken over the day.
When we first started out doing the virtual sessions, we did break them up more than we do in person. But I think we find now that people are more used to deal with things virtually, that it's maybe not so time for people. But what I tend to do, or what I have done, is maybe start like say at 9:30, have a morning break so you're not on your screen, and then carry on, have a bigger break at lunchtime, and again do the same in the afternoon. Just so they are broken slightly smaller chunks. But I still think we probably get through the evidence on that basis. Mr. Atkins, are you happy with one day?
Yes, my view would be that we should be able to cover the material in a day.
Okay, I think we'll just go for a day. I think, as I say, I think some of the matters might not need much discussion once I get your hearing statements and rebuttals anyway. There might be, and I'll come on to maybe vote for agreed matters as well, which might help. But I think even if we have breaks, I think we'll manage to fit it in a day. So if we go through Appendix A, just so we can go through the timeline, I've added in there obviously the pre-examination meeting, the note of meeting will be issued by the 2nd of August, and then parties confirm their participation by the 16th of August. And that's the procedural point I just discussed. Now, for the hearing sessions, I clearly require a hearing statement from both parties, and this must provide full details of the case that will be put forward in respect to the matters that we've identified, list the documents that will be referred to, and specify the witnesses that will take part and what those witnesses will cover. And I've said that this will be submitted by the 1st of September, and that was to allow a wee bit of time during the holiday period as well, in case key witnesses or people were away on holiday until the schools got back in mid-August. All documents must also be submitted on that date that you want to. I also think we should do rebuttal statements in response to the other parties' hearing statements. And again, that I find that just allows all the issues to be narrowed down to those that are in dispute, which again makes the time we have at the hearing more efficient. And I've said they should be submitted by the 22nd of September, so that's 3 weeks between the hearing statement and rebuttal, which hopefully give parties sufficient time to discuss the hearing statement with their team and come up with the rebuttal statements. On the back of that, I will issue hearing agendas on the 29th of September, the week later. And what I've done in previous hearings is they are fairly detailed agendas. They are in the form of questions as opposed to headline points for discussion. So you've got plenty of time to prepare. It's not precluding other questions coming up during the course of the hearing session. And it may be that I have other questions as I ponder between issuing agenda and coming to the hearing session itself. But the aim is to really flush out all the issues I really want to discuss and the questions, so that when we get to the hearing session, we can get right in. I won't be expecting people to make like open submissions or introductory remarks or anything like that. I will just go straight into the questions on the agenda. again, to make it very efficient, and so we're focusing on issues that are in dispute and things that I need additional evidence on. But I'll put them out on the 29th September. As I said, I'll issue protocols or ground rules at that time as well. And we could do any testing from the 29th September onwards if we need that. And the hearing session would be the 13th of October. I suppose just in that timeline, is everyone fully comfortable with that, or does any of that cause any logistical or practical problems for anyone? If we could start with Mr. Mitchell.
Thanks, ma'am. No, I think both in terms of the timetable set out in Annex A and also your proposed approach that you've just talked through there, we're the appellant's very content with both those things.
Mr. Atkins?
Thank you, ma'am. Yes, I think I'm comfortable with that. I'm only hesitating slightly because on the council's education side, we are going through a degree of change at the moment in terms of key personnel. So at this precise moment in time, I'm not entirely clear who my witness would be in terms of education, but I would hope that will become clear in the next few days, and we should be able to produce statements and rebuttals in the time period you've set out.
Okay, it would be helpful if there are any issues, if you could flag it this week before I kind of put the note out, and I can go back to parse if I need to for any further input. But hopefully that does work. But please do come back this week if you're faced with any difficulties.
Thank you.
Because kind of there's no point in me doing hearing sessions if I can't get the best evidence I need.
Exactly.
So please come back this week, because the note will go out on Monday with those dates, and they'll be fairly fixed at that point, just so we can get the timeline in place. Okay, so thank you for that. I did wonder whether there was any scope for agreed matters, or a statement for agreed matters between the parties, particularly perhaps around the statutory framework, development plan policies, Circular 3/2012. I wonder what parties' views were on that, Mr. Mitchell.
Yes, Mr. Atkins and I haven't discussed that, but and I certainly don't want to speak for him, but I agree with you. I think on the face of it, I think there's certainly the first two bullet points in your section 5. I think we could have an agreed position on those, and certainly from the appellant's point of view, we'd be happy to explore other areas where we can agree matters.
Mr. Atkins.
Yes, as Mr. Mitchell said, we've not actually discussed it yet, but I would imagine that there are areas that we can achieve agreement on that we therefore don't need to be getting into spending time on at the hearing, or potentially getting into arguments over things that we are actually in agreement on.
I think from my perspective, it would be useful, because often not only does it flag up the areas in agreement, it really highlights the areas in dispute. And maybe certain aspects of policy are agreed, but you can flag up the areas that aren't agreed, and we can focus on them at the hearing session. It would be helpful if perhaps Mr. Mitchell, for the appellant, you could lead on this. It would be helpful if there is going to be a statement of agreed matters, it could be submitted as a document on the 1st of September too. Does that sound okay? That gives you sufficient time to explore that.
Yeah, ma'am, I suspect it would, and I'm just thinking off the top of my head here. I wonder if it, depending if it would suit you, whether it'd be better to have it on the 22nd with the rebuttals, if we've got an opportunity to look at each other's hearing statements first. It may be that we can agree these things up front, and we can just not consider them in our hearing statements. I'm quite open to either option. It was just, as I say, just sort of thinking out loud.
Mr. Atkins, do you have a preference?
No, I mean I can see that there's arguments both ways, so I don't have a strong view either way.
I can see there's merits in both options, actually. I'll have a think about that, and I'll confirm in the note of meeting, because I can see pros and cons for both. Yeah, so I'll always think about that, and it'll either be the 1st or the 22nd. but I'll confirm that in the note. Okay, thank you. On closing submissions, I'm not minded to ask parties to make a formal closing submission in writing. But what I would do is give both parties the opportunity to sum up their cases at the end of the hearing session. Now, obviously, if we were pushed for time in the hearing session, I would reconsider that and give you time to put something in writing if we felt we hadn't got time to make an oral closing submission. I just feel that it was unnecessary time spent because I'll probably have enough information from the hearing session itself, and it's quite a discrete point. But again, I'll take parties' views on that, Mr. Mitchell.
My preference, if I'm honest, ma'am, is to do a written closing submission, but I'm very happy if time allows to do an oral one on the day of the hearing session as well. I suppose it may be helpful to have some guidance in terms of the duration of those closing submissions or the time allocated for them, and I appreciate that might be driven by where we actually are on the day.
I mean, I would expect no more than kind of 5 minutes.
Okay.
Just a summing up of the key points that you'd want me to kind of particularly leave the hearing with in my mind, that kind of thing, as opposed to a summary of your entire case.
Okay. Well,
so it's really drawing out the key issues you'd want me to focus on from your perspective. So kind of no more than 5 minutes is what I'd be thinking.
Okay, well,
does that help?
Ma'am, on that basis, I would say dispense with the written closing submissions for sure. I'd be happy on that basis then, if it's a summation of the key points.
Mr. Atkins.
I'm comfortable with what you've just outlined, ma'am.
Okay, thank you. And as I said, if we got to the point in the hearing session that time didn't allow, I would also reconsider that and make a discussion at that point. I wouldn't want anyone to feel that they haven't had an opportunity just to make some kind of summing up at the end on the key points. Okay, so I think we've covered everything at item 6. So item 7, which is the documents. As again, you'll probably both be aware, any documents submitted, including the hearing statements and rebuttals, should be shared electronically with the other party and copied to the DPA case officer. I'm not trying to kind of ask you to tell me how many documents you're going to submit. I mean, there is evidence before me anyway. But what we found for virtual sessions is that it is easier for parties to be working off either paper copies, but everyone does that. I have some paper copies, but often we work from obviously your screens, and it's handy to have all the documents and hearing statements on a memory stick. So you're not trying to download things from the internet if you're in the hearing session, because that can be a bit slow when you're on WebEx at the same time. And usually we ask the appellant to provide memory sticks for both the other parties and myself. And I just wanted the appellant to confirm that would be acceptable in this case.
Ma'am, yes, I think it would be. We have, I think, as a lot of businesses do, we veer away from memory sticks, but I don't think there'd be any difficulty in getting hold of some memory sticks for this. One suggestion I was going to make, but I think from what you've just said, it wouldn't help, is that in previous hearings we have as a firm, we've hosted a data site where we've put all the documents up there, so they're clearly set out in an indexed manner and they're accessible, but that would still involve going online and viewing them from a web source rather than from a hard source on your computer. So that's maybe not something you wish to consider, and especially in light of the fact I think that it will not pose a problem to produce a memory stick.
Okay, Mr. Atkins, do you have any comments?
I'm comfortable with what's been. I mean, I suppose with what Mr. Mitchell suggested as a kind of core document online library. I suppose if there were the opportunity for parties to effectively download, ensure that the documents have been downloaded prior to the actual session starting, that might hopefully eliminate issues of poor connectivity if that occurred during the meeting. So that might be, because like like Shoesmiths, the council's largely moved away from memory sticks as a means of. I mean, you know, for this session, if that's the agreed way forward, I'm sure we can work with that. But yes.
I'm happy if you're happy not to memory stick and to download your documents ahead of a hearing session. I'm happy to go with that. I'm not anticipating there can be reams and reams and reams of documents either. So if you're happy that you'll organise yourself in whatever way suits you for the day of the hearing, and Mr. Mitchell, you're the same, I'm happy to dispense the memory sticks too, because I can also just make sure I've got the documents handy. So I'm happy to dispense that if parts of the council not between that basis. Obviously, they'll all be on our website anyway. If you wanted to make a folder available, Mr. Atkins, he's got it in a document cloud type thing, then I'm happy with proceeding on that basis too. It would just make it easier on the day, but I've got no fixed way of viewing it if the parties are happy to proceed without memory sticks.
Yeah, I just from the appellant's perspective, ma'am, we would be happy to proceed without memory sticks. That said, I mean, I would still be happy, or my firm would still be happy to host a data site where, you know, all documents could be seen. I know they will be on the DPA website, but if that would help parties as well, that can be arranged very, very quickly. I mean, the document submission date of the 1st of September, I suspect we could have it up and running on the 2nd of September. It's that straightforward to do, and parties could have access to it if that would assist.
Is that Atkins, that assists you? You're happy with that?
Yeah, I think that's welcome, and I thank Mr. Mitchell for the offer. And in practical terms, that might have the capability of working, hopefully working well in the virtual world.
Okay, I'll confirm that in the notes, but thank you for offering that. It sounds like a good way forward. During the period of the restrictions for COVID-19, the council is not required to place any of the case material on deposit. I don't know if that'll change, if the restrictions change, but we will confirm if that does change. But everything will be on our website in the meantime anyway. So if there is any change, I'll let you know. But at the moment, the rule is, or the restrictions are, that you do have to put it on deposit. Okay, moving on to site inspection. Now, given the nature of the appeal, I don't think I need to do a site inspection. I have thought about it. I know where the site is. I'm familiar with the area. I just wonder if parties are content with that, or is there anything that you'd want me to go and see in the context of the schools or other developments that parties referred to? Mr. Mitchell.
Not from the appellant's perspective, ma'am. I think if you were minded to do a site inspection, we would clearly have no real submission to make on that, other than I suspect an unaccompanied one would be more than adequate for you. But no, I don't think the issues that are both at stake and in dispute in the appeal turn on the location.
Mr. Atkins.
No, I would agree with what Mr. Mitchell's set out there in terms of site inspections. I don't think there's a need given the issues at hand in the appeal.
Okay, thank you. On that basis, I won't do a site inspection. As I say, I know where the site is, in the locality of the site, so I won't do one. Okay, we went to item 9, DPA contact. You've both been in contact with Laura Walker, who's the case officer for this case. She should be contacted in the first instance if you've got any queries or anything. I will put her contact details in the notice of meeting just so it's handy in case you're looking for them. And then moving swiftly on to item 10, be very quick meeting. Any other business? So, Mr. Mitchell, do you have anything else you wanted to raise this morning?
Nothing else for the appellants, ma'am.
Mr. Atkins, anything for the council?
Nothing else from the council, thank you, ma'am.
Okay, well, that shows how efficient virtual meetings can be. So thank you for taking part. As I've mentioned, I will prepare the notice of meeting and that will be circulated by next Monday by the case officer. If there are any issues with Atkins, your witness or the timeline, then you could get in touch before the end of the week. That'd be really appreciated before the note goes out. and the note will be published on the website. Everyone who's in attendance today will get a copy anyway. So all leaves me to say, well, thank you very much for your time, and I will formally close the meeting so you can all log off.
Thank you very much.
Thank you.
Thank you.